Hello everybody. Our group is Group in Demand. We are 3 members in our group. Myself, Visma Thapamagar, Sujan Malpul and Birsumit Limbu Pehim. So our presentation is going to be on analyzing workplace documentation and legal strategies. It will be case studies on Sara Lopez versus NovaTech solutions. So without further delay, let's get started. Introduction. Workplace disputes involving discrimination and retaliation requires more than personal testimony to succeed in legal or tribunal proceedings. Documentation of incidents plays a decisive role in establishing credibility, proving a pattern of behavior, and ensuring evidence is admissible. uh, this case discusses the financial case of Sara Lopez versus NovaTech Solutions, reviews the implications of approximately documenting to support her claims, and discusses the legal aspects pivotal in employment law, specifically the archery rule plus the exceptions. Background of case study. Background: Sara Lopez is a senior software engineer at NovaTech Solutions, a company established in Toronto with approximately 250 employees. During her 5-year tenure at the firm, she has had consistent performance review at the level of exceeds expectations and held to key projects, as well as won 2 domestic awards of innovation. Chronology of events. Incident 1, January 8. Does not Sara does not get invited to the kickoff meeting of this project called Project Orion. Although she would have been the most successful, most seasoned engineer in the department. In retrospect, a fellow worker says management had been seeking out fresh faces to promote all men. There is no official explanation. Incident to March 15. In one instance, in a group lunch, Sara is told by her direct manager, Mark, women in tech belong in the UX where it is less stressful. 3 of the colleagues are present when the remark is made. At the moment, Sara does not react. She is humiliated. May 2 Incident 3. Sara goes to HR to complain that she is not involved in projects and some comments are discriminatory. HR does not motivate an official investigation but merely takes note of a complaint. Incident for July 10. Sara has been experiencing that for 2 months. Since her HR complaint, her workload has been lessened and she is excluded from client meetings that she used to attend. Or Meteor project falls to needs improvement with no details. Incident 5, September 3. Sara is put under a performance improvement plan (PIP) with impractical timelines. She fears reprisal due to her complaint to HR and is inquiring about legal advice on her possible rights to human rights and wrongful dismissals. Uh, from the next slides, uh, our group member Birsumit Limbi Payne will discuss on the documentation strategies of Sara Lopez versus Nova Scotia Tech Solutions.
Now that we have covered the background of Sara Lopez case, I will focus on how she should document incident in a way that support our claims. First, the incident to document. Sara should detail records of any discriminatory comments or behavior changes to her workload assignment after she complained and any performance review that appear distorted or unjustified. She should also keep copies of HR response, whether that mails, emails, meeting notes, or internal messages, as well as the witness statements and evidence of being included in or excluded from the key meeting or opportunities. Second, using the 5 Ws. Each record should answer who was involved, names, job, title, and roles, what happened, the exact word or action, ideally using direct quotes, when, date, time, and duration, where, the physical location or digital platform, witness, full names and contact details. By inserting Sara create a complete, credible record of each incident. Third, avoiding hearsay. Sara must stick to the what she personally saw or heard. For example, instead of saying Alex told me that Mark said, she should record Mark said in my presence. That this ensure our notes are first-hand account, not second-hand information, which strengthens their admissibility. Fourth, using technology effectively. Sara should back up relevant emails in separate folders, save screenshot of Slack, Teams, or Zoom message with visible timestamp. Keep an incident in log in secure, password-protected cloud folder, and maintain a backup on a secure USB. Finally, an example of whole document incident. Let's take the March 15 launch comment from our manager. Date and time. March 15, 12:30 p.m. Setting company cafeteria. Present Mark, manager, Jake, developer, PI, UX designer, Michael, QA lead. Description. Mark said, women in technology ought to remain in UX since it is less stressful. This was unsociated and framed as joke. Sara did not respond. Priya appeared embarrassed and looked down. Witness Jake, Priya, Michael. With this level of detail, Sara is not just keeping memory, she is creating evidence.
So hi, it's me Susan Naval, and I'm talking about the legal analysis. And first one is the value of evidence. So the employment claims and human rights are normally dependent on the trustworthiness of the complaint. Witness statements, especially those where written documentation, is form vital connections that are gathered in an investigation into HR matters and tribunals. So in the second part, there is the rule of heresy. Not only is heresy admissible in the Ontario Human Rights Tribunal, but it can also give decreasing weight. So some of the exceptions which are included here are business record exception, meeting minutes, HR reports, internal memos are those which are related in business record exceptions. Second one is the admission by a party opponent, statement of managers or company representatives, and the last one is past recollection recorded, which is also described as a record written down quickly after an occurrence when it is still fresh in the mind. So the records at the time and stored communications of Sara being belong to these classes, which reinforces admissibly. So in the next part, which is elements of admissibility, and there is also one point like timeliness, which is described as the nearer in date the note is to incident, the more it seems to be credible note. So this is a phrase from the timeliness, and it's in original format like unedited files and screenshots as well as emails are better than revised summaries, which has one of the main point corroboration, which means that when two or more witnesses give similar information or when two or more records are covered in the same way, the reliability is enhanced. The pros and cons can be described as, first one is the benefits, which is like it creates a written history of bias, discrimination, and revenge. It improves the level of credibility with the HR or the court of the law. And the last one is that it may foster early settlement when the strength of evidence is apparent to the employer. And at the last but not the least, the risks. The risks are as follows: the possibility of breaking the confidentiality rules of the company due to the removal of sensitive files from the workplace systems. So when a case is over documented, records on the trivial issues may sabotage the seriousness of the case. When the employer finds out about the details of these records, there could be possible retaliation on that topic. So in the fifth part, there is an ethical consideration, like when regarding workplace conflict, employees are required to have integrity. Making up or inflating facts can cause loss of credibility and can be grounds for dismissal. And handling of confidential data must be observed, and sensitive client or proprietary information included in personal records must be withheld. So on the another side of ethical side, documentation has two functions, namely the safeguarding of the rights of the employee and allowing the employer to articulate valid matters before boiling over. And at the last but not the least, in the conclusion part, there is in the context of Sara Lopez, it can be variation between a disregarded complaint and a worthwhile claim that requires careful documentation of NovaTech solutions using the 5 W's: shunning heresy and retaining authentic documentation. Sara can give reliable evidence that can be accepted in court to support our case. And at the last, documenting in the workplace is more than self-protection, rather than it is a professional and ethical course of action when dealing with misconducts and holds an individual responsible to react fairly. So thank you so much.